Misdirecting the jury. We're going to look at the UK directions in criminal court. This video will let you know the power of the court to intervene with good or bad character evidence being introduced to the jury by directions of the court in UK criminal law proceedings. As it's nice to have a visual of what I mean, I'll play a short clip of the opening statements from the Attorney General for the state of South Carolina versus Alex Murdaugh trial that's currently going on in the county of Carleton in the USA. Straight after that, I'll play a clip of the 911 call that the defendant made. That would be equivalent to 999 in the UK. See if you can catch a misdirection that the state attorney did, and then I'll point out what I noticed. So let's get started.
We'll now proceed to opening statements by the state.
Thank you, Your Honor. May it please the court. On the evening of June 7th, 2021, at the defendant's property off Moselle Road in Colleton County, his son, Paul Murdaugh, was standing in a small feed room and some kennels they had on the property. About 8:50 p.m., and the defendant over there, Alex Murdaugh, took a 12-gauge shotgun and shot him in the shoulder, in the chest and the shoulder with buckshot. And the evidence is going to show it was a 1,000,000-to-1 shot. He could have survived that, but after that, another shot went up under his head and did catastrophic damage to his brain and his head. All collapsed right outside that feed room. And just moments later, he picked up a .300 Blackout, which is a type of ammunition, but an AR-style rifle, and the evidence is going to show that the family had multiple weapons throughout the property, picked up that .300 Blackout rifle, and opened fire on his wife, Maggie, just feet away near some sheds that used to be a hangar. Pow, pow. 2 shots, abdomen and the leg, and took her down. And after that, there were additional shots, including 2 shots to the head that again did catastrophic damage and killed her instantly. The evidence is going to show that neither Paul nor Maggie had any defensive wounds. Neither one of them had a 911 call. And on the body-worn cameras, pay attention to what he says. Look at how he's acting. But he says within a few minutes of each one of those, he says, this is about the boat case. This is about the boat case. And you're going to hear some of what was going on in Alex Murdaugh's life leading up to that day.
This is Alex Murdaugh at 4147 Moselle Road. I need the police to stand immediately. My wife and child was stuck badly.
Okay, you said 4147 Moselle Road in Allison?
Sir?
You said 4147 Moselle Road in Allison?
Yes, sir. 4147 Moselle Road.
Stay on the line with me, okay? Yes, sir. Stay on the line with me, okay?
Hello?
I'm still here. Stay on the line. I'm still here, okay? Carlton, I have an Alex Murdaugh on the line calling from 4147 Moselle Road. He's advising that his wife and child was shot. Mr. Murdaugh, go ahead and talk to Carlton.
It's 4147 Moselle Road. I've been up to it now. It's bad.
How did they shoot? Did they shoot themselves?
Oh, no. Hell no.
Okay, and are they breathing?
No, man. He's been being threatened by my son's had a boat that he's been being threatened for months and months and months. He's been hit several times, and
Did you catch that? The 911 operator actually asks him, did they shoot themselves? It goes to reason when law enforcement were on the scene, he wanted to make it clear that they did not shoot themselves, that there was ongoing threats regarding the charges against his son, the boating incident. So you think the state is trying to mislead the jury, or now do you think it was a reaction to the 911 operator? Or was he just trying to mislead enforcement officers like the state attorney is trying to suggest? So to counteract some of these misleading interpretations of the evidence, in the UK, defendants are allowed to put forward a defense of good character in criminal proceedings. And it is admissible as it can go to either the propensity or credibility or both. Propensity means that the defendant is unlikely to have committed the offense from which they are accused, and credibility means the defendant is more truthful than someone without such a good character. So the reason for this is if someone has an absence of convictions, doesn't necessarily mean a defendant is of good character. And where there's a reliance on having a good character, it is the duty of the defense counsel and the defendant to ensure that the judge is aware of this. Where there is a doubt, it is good practice for the judge to raise the matter with counsel. Any proposed good character direction should be provided to counsel and the prosecution, and the defendant should have the opportunity to make these submissions regarding this evidence. So, criminal procedures in the UK, the judge has the power to give directions to allow character evidence, if it's bad or good. It needs to have a probative value, meaning it needs to be able to be questioned. And if it outweighs a potential prejudice against the defendant, meaning for justice to be served, it is important for the jury to hear the evidence, then it should be admitted. So, character and background evidence for the commission of an offense may be informative, but where it discloses past misconduct, it can be unduly prejudicial. That's why it's important to find a balance to ensure fairness for both sides. Okay, with that in mind, let's watch another clip of the Murdaugh proceedings, where the state is questioning a friend of Paul Murdaugh, the son of the defendant that was shot, and see if you think this line of questioning is fair or prejudicial, or are they trying to sneak in some evidence of financial problems that Alex Murdaugh law firm has been having.
Paul and Alec and Maggie, is that correct?
That is correct.
To your eye, it was a very good relationship, is that correct?
Yes, sir. It was a good relationship in my point of view.
Did you know anything about Alec's finances?
No, I did not.
Did you know anything about his law practice?
No, I did not.
Did you know anything about where he gets his money?
No, I did not.
Did you know anything about where he was spending his money?
No, I did not.
Did you know anything about what his bank account balances were?
No, sir, I did not.
Did you know anything about the debt that he was carrying? Do you know anything about that?
No, sir.
Did you know the specific things that were going on in the boat case the week that Paul and Maggie were murdered?
No, sir.
Do you know anything about civil discovery and how it can expose financial information?
No, sir.
Do you know anything at all about him being confronted on June 7th, 2021 about...
Object.
Didn't hear the question.
Did you know anything about him being confronted on the morning of June 7th, 2021 about $792,000 of missing fees from his law firm?
Objection, Your Honor. But totally improper.
Objection is overruled.
Did you know anything about that?
No, I did not.
Do you know any of the facts of those things that I just asked you about?
No, sir.
So what'd you think of that? The judge explains on day 7 the reason for this overruling that the defense is objecting to in the clip we just saw, allowing this witness to answer the question about if he knew if Alex's law firm was in financial trouble, or that he had notification of a civil lawsuit that very day. So in the current trial, day 7, where he explains his ruling, he refers back to an earlier ruling. And to be fair, it sounds very similar to my short explanation of how good and bad character evidence would be considered in a criminal case in the UK. In my view, I sure hope the jury is taking notes, but unfortunately in this trial they are not allowed to take notes. So the witness in an earlier clip of this testimony, he testified that Alex Murdaugh sold a property to pay for his son's legal charges and civil suit over the boat charges. I sure hope they caught that, as it also shows that the father was committed to supporting his son. Some interesting background: I read the court had to take portraits down of the defendant's grandfather and great-grandfather that stood for many years in the court, as they were the elected prosecutors for many years. You can read that article, as I've left a link below. So what are your thoughts? Are you watching this trial? As this is a really interesting case. Remember, if you are going to bring good character into an argument, it will be fair game for the other party to bring evidence to counteract it. Well, I hope you found today's video interesting, and information is power. Why not subscribe and watch more of our videos? If you need legal help, contact legal-minded friends.